Coffee, a cold shower, and fresh air can make you feel sharper, but none of them speed up how fast your body clears alcohol. Your liver burns off alcohol at a fixed rate, and that rate is not something you can change. In fact, your blood alcohol can still be climbing after you stop drinking, so you might leave a party feeling fine and be higher at the roadside than when you walked out the door. Feeling okay is not the same as being under the legal limit. Most drivers over 21 who are not on DUI probation are surprised to learn that the walk-in turn, the one-leg stand, and the follow-the-pen eye test are voluntary. These are not pass-or-fail tests designed to clear you. They are evidence-gathering tools, and they are scored on subtle cues that can trip up a perfectly sober person. Similarly, the small handheld breath device at the roadside, called a pass, is also generally optional for adult drivers not on probation. The pass reading governs whether there was probable cause to arrest you in the first place, but the evidentiary breath or blood test the officer requests after a lawful arrest is a different story. California's implied consent law requires that post-arrest test, and refusing it carries its own separate penalties. The 0.08% threshold gets most of the attention, but it is not a safe harbor. Vehicle Code 23152A is a separate charge that covers actual impairment, meaning a prosecutor can pursue a DUI even when your number came in below 0.08 if the evidence suggests your driving or behavior was affected. That same impairment standard also reaches prescription drugs and cannabis, because the law targets impairment, not just alcohol. And drivers under 21 face a zero-tolerance standard where almost any measurable alcohol can be a problem, with no 0.08 floor at all. A number on a breath test printout is evidence, not a verdict. Breath instruments have to be properly calibrated and maintained, and the officer has to follow a specific observation and operation procedure. Conditions like residual mouth alcohol from a recent burp, certain medical conditions, or even acid reflux can push the reading higher than your actual blood alcohol. The prosecution relies on the Title 17 governed evidentiary result from the station instrument, but that result can be contested on calibration records, maintenance logs, and the circumstances of the test itself. Results vary case to case, but these are recognized and frequently litigated challenges. A first DUI is a criminal misdemeanor, not a traffic infraction. Even without a prior record, you can face probation, a mandatory alcohol education program, court fines with penalty assessments that multiply the base amount several times over, and a license suspension. There is also an option to install an ignition interlock device for roughly 6 months in exchange for keeping full driving privileges, though on a first offense with no injury that is generally a choice rather than a requirement. A restricted license without an IID is an alternative. On top of all that, a conviction affects your insurance rates and shows up on background checks for years. The last myth is the most costly, that DUI cases cannot be challenged, so you should plead guilty at the first court date and move on. DUI evidence is regularly contested on the lawfulness of the traffic stop, the reliability of the testing, procedural compliance, and the overall strength of the proof. Entering a guilty plea on day one means giving up every one of those opportunities before anyone has actually reviewed the evidence. There is no promised result in any case, but a defense that is never explored is a defense that is never used. Understanding what the law actually says, rather than what people assume it says, puts you in a much better position to make real decisions about your case. I'm Joel Brand, a California DUI lawyer. This is general information, not legal advice. If you want a free written case analysis, it is at DUI.guru.